I can't hear anything.
Mr. Martin?
Oh,
Well,
All right, Mr. Martin, I just want to clarify something because I am inclined to grant your motion for the appointment of counsel. But the problem is inside your motion for counsel, it also states that you are not consenting to the jurisdiction of the court. So if you're not consenting to the jurisdiction of the court, how is this court supposed to grant your motion for appointment of counsel?
It makes no sense to request a lawyer but not consenting to the courts. I mean, I'm proud of him for finally getting a lawyer after making an ass out of himself, but come on.
I already have jurisdiction over you. That's already been established, clearly. So do you want counsel? Because if you do, I'm going to appoint counsel.
yeah, I still want the counsel, but like I said, without the fraudulent presumptions and all that. But
Sure, hang on. If you could speak up and enunciate, because I don't know if it's maybe a connection error or if I'm just having trouble hearing what you're saying. So I just want to make sure that what you're saying is clearly stated on the record, okay?
okay. Let me move my phone up away from my desk. I think that's a little too close to the desk. But yeah, still want counsel.
Okay, so you are consenting to the jurisdiction of the court, and I can grant you counsel, yes?
No, I'm not consenting to the jurisdiction of the court.
I don't know what you're saying, sir.
He said he's not consenting to the jurisdiction.
You're not consenting to the jurisdiction of the court?
Okay, so you don't consent because he doesn't have jurisdiction over you. I'm sorry, but I feel like they already do, and that's something you should know. So get a lawyer, shut your mouth, and grow up.
Well, I've already found that. Then first off, I find that I do have jurisdiction over you in this matter. You came to the location, like I stated before. You came into the location and availed yourself of all of the benefits and services that you can find here, emergency services, road services, etc. You actually reside in the city of Taylor, so that alone is enough to have jurisdiction over your person in this matter that occurred in the city of Taylor. So I do find that I have jurisdiction over you. So that matter is settled. Would you like to have counsel?
That's not true, so I object to that. That's not true. You never gave me how you jurisdiction.
What part's not true? Do you live in the city of Taylor?
No, I'm not going to say that it's true as in, not in the sense that you mean it, no. Or you're asking, it's fraudulent.
So you do you astral project into the city of Taylor then from somewhere else? Or I don't understand. Living is, I don't know, breathing, live, reside, Clifford Street, you know what I'm saying?
Yeah, I mean, well,
keep stuff.
The thing is, if someone, stays in a house, it's fraudulent presumed that the corporation, the fiction they're living in, it's all legalese.
All right, so you're not a corporation. I do find that you have jurisdiction. I have jurisdiction over you. I will note your objection for the record, that claiming that that's not true. I am going to appoint House counsel to you because you definitely need somebody who can understand and explain the law to you and be on your side with regard to the case. So I'm going to appoint House counsel again. And I'm going to put you into the breakout room, and House counsel will be in to speak with you so you can speak privately.
All right.
Breakout room 3, House counsel 3.
It's just the law doesn't allow me to do certain things. And Mr. Martin disagrees with the law, and that's his right. But Mr. Martin's come to the conclusion that he doesn't believe that I can effectively represent him. And after, like I say, over 2 hours of discussions with Mr. Martin, I believe I'd have to agree with him.
You are agreeing that the two of you disagree, or that you just can't represent? Because I guess I would have to disagree with your own statement because I think you're very confident in every case I've seen.
No, I appreciate that, Judge. But based on our internal disagreements, in terms of how the case should proceed, what the law is,
Strategy.
how to apply the law. I just cannot, in his mind, effectively represent him. And I can't represent him the way he wants me to.
So you believe that he believes that you,
I do, yes.
not that you actually wouldn't be.
No, I'm in terms of this case, I'm more than able to go forward with it, but under the circumstances after, again, this is based on a long conversations with Mr. Martin. Just don't think that he's comfortable with me proceeding.
Mr. Martin, is that correct?
That's correct. Is yes, we certainly don't agree. We did talk for a long time, and but it's not simply just a disagreement. I don't think he's violating my right to effect from counsel based on one. He wouldn't even do the basic photocopies, some paperwork. I told him I wanted to get photocopied, for the court and jury, such as laws, be used for my defenses, relevant to my defenses.
Sure, but you do understand that any instruction on the law to the jury is done by the judge. You understand that?
Well, I don't understand. I don't agree with that, or
No, sir.
please.
I literally am charged with instructing the jurors on what the law is and what the elements of the case are.
I mean, that's fine.
I'm going to instruct the jurors that any instruction that they hear from the attorneys to disregard, and you're only going to take instruction about the law and what the law is from me, because there's literally criminal jury instructions that are put out by the Michigan Supreme Court that are used in trials, and they've been vetted over the course of hundreds of years of tweaking and Supreme Court challenges and you name it and everything else. So that's literally what the jury is getting told, is they're going to get told what the law is, and that's going to be told to them by me. You understand that, right?
But but I don't agree to that degree, but to that degree. But as long as you don't knock out my right, I also have the right to present jury instructions on the law of the matter. So, so long as
you have the right to present proposed jury instructions, yes. And I'll make the determination of what the jury instruction, what the instructions will be to the jury. So, but first, let's deal with this matter here. You're saying that you no longer, you wish to have the court-appointed attorney, and now you do not wish to have this court-appointed attorney. Is that correct?
But only in the sense of I moved to have another one appointed in his place, since he's being ineffective based on he won't even photocopy, not just the mere disagreement, but it's the fact that he won't even photocopy. I asked him to, let me go there first to the office, photocopy, so I have enough copies for the jury, because I don't have a job now, so I can't.
Well, photocopy what, sir? You want him to photocopy what?
I have just several things written down in the law and things that need to be copied out of the Constitution. Just several legal, several legal areas to be copied out of the law, and just stuff that's relevant to my defense. So he should give me no problem with photocopying. That problem. So that's really showing his ineffective, violate my right of it. So
yeah.
So the only reason why he wanted a lawyer is because he can't afford to photocopy his paperwork. And that's the only reason why he wanted a lawyer. And the lawyer would do it because it's all about the sovereign BS. And so now he's like, I don't want one. He won't photocopy all my paperwork. Like, I would say no too. I'm not even a lawyer, but I would be like, oh no, like this is all BS. Like, dude, let's do it the right way. He's so confusing, and he's old, like in his 40s. Like, get it together, dude. Like, cut the shit, cut the bullshit, and just have a lawyer and do it right, and just shut your mouth, okay?
Listen, that's not photocopying is not an attorney's job. If you want something photocopied, go to the library and photocopy it yourself. The attorney's job is to talk and understand and be able to give advice about the law. He already knows the law. He doesn't need a photocopy in front of him. He already knows what the law is.
But as I just said, based on I do not have a job now to pay for the copies.
Oh, so you want them to pay for, so that's the rub. You want them to pay for photocopies that you want to make.
Right.
Well, you're more than welcome to just have but listen, your attorney doesn't need the law in front of him. He already knows what the law is. So if you want a copy of what the law is, you're more than welcome to go to the library and check out a book that has the law in it. You can just bring the book with you. And take the book back to the library afterwards, free of charge.
Again, I need paperwork photocopy that's relevant for my defense to present it to you and the jury. I have that right.
First off, listen, you're not presenting any paperwork to the jury if it's about laws. If you're going to try to place things into evidence, you can lay a foundation and you can put in proposed exhibits for evidence. And then I'll make my rulings based on the rules of evidence of whether or not those are supposed to come in and should come in, and whether they've had proper foundations laid, whether they are both reliable and accurate. That's the two things that we're really looking for. So, and if they comport with the rules of evidence, then I'll admit them as your defendant's exhibit, whatever, 1, 2, 3, or 4, whatever the exhibits that you have are. So. This is a situation of driving on a license that's been revoked or restricted. So what evidence is it what proposed evidence do you have that you would need? Because we'll make copies here of that evidence as it gets admitted. Because I'll put a true copy in the court file. I can give a copy to the witness so they can see. So that kind of thing. But so as far as the motion to remove Mr. Fanto and the House Counsel crew that I have here, which includes Mr. Gazicki and Mr. Coots, I'll once again grant that motion. I'm not gonna request any fees or anything or costs from you, because I did appoint them. Then you said you didn't want them. Then you asked for them. Then I gave them to you, and then you went back and said you don't want them now. So with regard to a different attorney, do you have another attorney that you wanted to hire? Is that what you wanted to do? Or you want me to appoint one to you?
I don't have money to hire an attorney.
Sure. So I'm going to go ahead and appoint one to you. I can pretty much, let me just take a look here at the possibility. All right, so I'm going to refer this to Miss Patton from the MIDC, and I will have an attorney here for you Tuesday for that jury trial. We'll be ready to go.
Well, that's what I wanted. Now, another attorney being appointed.
We'll see you on Tuesday, sir. I'll have a court-appointed attorney here for you.
Okay, but
All right, see you Tuesday.
Thank you.
Motion granted.